to have two distinguished experts to take us through some of the new norms and what we are likely to see, their legal implications, and to answer some of your questions. I'm very pleased to introduce our moderator for this webinar, Emily Kamunde. Emily is a very experienced trainer, a facilitator, and a professional coach. She has worked for many years as an HR business partner and now runs her own consultancy practice, Rise and Learn. Emily brings a huge amount of enthusiasm, pragmatism, and a real understanding of the challenges facing organizations today. So I'm very happy to introduce Emily to take on from here, introduce our two speakers, and moderate this discussion. Over to you, Emily.
Thank you very much, Sandeep, and good morning to everyone. Thank you so much again for the introduction. I'd like to go on and introduce our speakers. I will start with the lady, Georgina Ogalo Omondi. Georgina is a partner at Oraro and Company Advocates in Dispute Resolution Practice Group. She has over 10 years experience and has represented and advised local and international clients on a wide range of intricate employment and labor disputes. Georgina has recently advised several large organizations in this country in matters relating employment restructuring, redundancies, and the like. Leading global legal directories have consistently recognized Georgina as a leading employment lawyer. Georgina has a double concentration in Bachelor of Commerce in Economics and a Bachelor of Laws, LLB, from the Nelson Mandela University, South Africa. She also has a postgraduate diploma from the Kenya School of Law. I'd like to introduce now Mr. Chacha Odera, who is the managing partner for Oraro and Company Advocates and practices in the Dispute Resolution Practice Group. He specializes in arbitration, alternative dispute resolution, and litigation, and he has over 30 years of experience. Chacha has been ranked by leading international legal directories such as the Chambers and Partners and Legal 500 as a leading lawyer in dispute resolution and employment. Chacha was also recognized as an overall lawyer of the year 2019 in the Nairobi Legal Awards hosted by the Law Society of Kenya, Nairobi branch. He holds an LLB from the University of Nairobi, Kenya, and a diploma of law from the Kenya School of Law. In addition to being an advocate of the High Court of Kenya, Chacha is a member of the London Court of International Arbitration, LCIA, Users Council, a commissioner for oaths, and Notary Club. Aside from that, in legal practice, Chacha is an adjunct lecturer at the Strathmore Law School and has chaired 2 ad hoc committees at the LSK. I could go on and on, but just to let you know that he's also a passionate philanthropist and currently an honorary member of the Rotary Club. Ladies and gentlemen, I'd like to welcome our 2 guest speakers for today. I think really interesting conversation we will be having around the future of work and the implications this pandemic is having in terms of also shifting our mindsets into how will our workplaces shift going forward. And let's have that conversation. Over to you, Georgina.
Thank you very much, Emily. I think, Chacha, you're going to do an introduction in terms of just before we begin.
Thank you very much. I'm most grateful being invited together with my partner, Georgina, to discuss this very novel situation that we find ourselves, both as employers and as employees. I must say that when I was called upon together with Georgina to share our thoughts on this, the first thing that came to mind is that we have been operating on what we had classified as a normal. But with the advent of the corona COVID-19 into the world stage, things have changed a great deal. The tectonic shift in relationships, contractual and otherwise, social and contractual relationships, have taken a completely new meaning. And it is a conversation which when had in this kind of platform, enriches the conversation. And indeed, we get an opportunity to share with each other what our various thoughts are. And that merely goes further into confronting this new normal that we find ourselves in. Georgina and I are partners at Oraro and Company Advocates. This is a top-tier full-service law firm established about 44 years ago. Our senior partner, George Oraro, who's with us, still is with us. He is a senior counsel. And in building the practice over the years, we have been able to provide specialized legal services, both locally, regionally, and I must say internationally, ranging from arbitration as a dispute resolution mechanism. Areas of practice have extended banking, finance, conveyancing, real estates. We also practice in corporate and commercial. And in so practicing, we have been engaged in various infrastructure projects, PPP projects, restructuring, insolvency, and tax. We do have strong ties with international law firms, and that has facilitated or enabled us be able to provide clients with services, not just with local knowledge, but with a global perspective. We have been ranked several times by various international directories. Leading of them is Chamber Globals, IFLR 1000, and Legal 500. And all these global directories have consistently ranked our firm as a top-tier firm. And we don't say that we are top-tier firm merely because we've been here for a long time, but it has been what our clients have thought of us and what they have shared with these various directories. And we are grateful to them for the support that they have given us over the years, the amount, the expectation they've had of us, and the information and this kind of forum that we've been able to share with them, so as to be able to sharpen our skills and to be able to be useful to them as advocates. Thank you very much.
Thank you, Chacha. As Chacha had mentioned, the situation we find ourselves in is that we are currently, I would say, in the midst of the COVID-19 pandemic. From the time that it was declared a pandemic by the WHO and the first case of the COVID-19 in Kenya on the 13th of March, life as we knew it has completely changed, both from a social and an economic perspective for the country. There were, following the announcement of the first COVID case, numerous directives by government that were issued with the sole aim of curbing the spread of the pandemic, and in itself changing the way we operate, both in terms of business and also how we socialize. We are still going through most of these directives and in the process of trying to see how we can, in essence, try and flatten the curve. Now, in these changes to our lives and directives issues, this created an unprecedented instability in the employment sector, with employers having to walk the tightrope of balancing both business continuity and sustainability, while at the same time trying to ensure safety and well-being of their employees. And really from the onset, from mid-March, we already started receiving queries in terms of how do we readjust how organizations operate, and also how people either work from home or work within the office. We're guided within the compliance guidelines given by the government. And coming up with that, we came up with the topics for discussion today, which is basically, we'll be looking at firstly the effects of the changes to employment caused by COVID-19 and their legal implications. And that is basically the directives and directives and orders given by the government in terms of how workplaces will be operating. We'll also be looking at the measures that organizations have taken to adjust, both from the workplace front and then also from a financial perspective and structural view of an organization. How have organizations been managing during this period of time? And then now that it's coming to a point where we've already gone through 2 containments and the extensions of the curfew, what will work be for us for at least the next 2 years, which is the predicted period of time that COVID is expected to be with us. Some have even predicted up to 10 years. So in essence, it is going to be changing how we'll be doing things going ahead. It really isn't going back to normal. This is the new normal. So how do we adjust and how do we comply from a legal perspective? Just to start off, I'd ask Earth, can you put up the first poll question? So the first poll question is, do you have a written policy to deal with the health and safety of employees at the workplace during this period of the COVID-19 pandemic? This question will actually really guide us into the first segment of the conversation.
I think as the polls are being responded to, I'd just like to note that there is a Q&A tab at the bottom. If you have any questions as we go ahead, please type them on there and we shall respond to them at the end of the session. Thank you. Earth, would you like to share the results now?
Well, at least I'm happy to see at least 50% already have in place a health and safety policy during this COVID-19 pandemic. And as you go along, we'll actually be looking at these policies and how important they are. And hopefully by the end of our discussion and probably by the end of this month, going into opening up of offices and also organizations picking up in terms of business, these percentages will increase. Yes was 52%, no was 48%. Now, the reason why I've asked if you have a health and safety policy with regards to this COVID-19 pandemic is that immediately after the first case of the COVID-19 was announced and the presidential address, I think on the 15th of March, the Directorate of Occupational Safety and Health Services released an occupational safety and health advisory on the COVID-19. The purpose of the advisory was to provide a national framework for workplaces to help minimize the spread and reduce the economic impact of COVID-19. Now, DOSH's main aim for the advisory was to ensure that employers at least have in place or formulate a policy with standard operating procedures on how to handle the pandemic in the workplace. And this comes on basically that they were seeking to require to have employees take all the necessary steps to minimize the risk of infection. Within the proposed policies that organizations are expected to have, this was used to minimize the risk of infection and in the process, promote and protect hygiene, encourage employees to practice social distancing, even within the workplace, allow employees to work from home in situations where that is a workable option, allow employees to work flexible hours to avoid peak public transportation time. Basically trying to reduce the contact between individuals, especially as you know it in our Nairobi, From 5 p.m., it's just human and both vehicle traffic, all directions. And those were some of the things that were being taken into consideration by the government and specifically DOSH. They were also trying to avoid, if possible, business travel only on a need-to-need basis, practice safe food handling. And even as recent as last week, there was a case where a microwave in an office caused at least more than 20 employees to be infected with COVID-19. And it's just those common handling areas and common places within the workplace that you'd least expect or consider to be a hazard to the workplace have now come up to be one of the key sources. They were also within their advisory seeking that each organization have a proper reporting system for suspected cases of COVID. And within this advisory, you'd ask, why is it so important for my organization to have a health and safety policy, or at least have mechanisms to deal with the COVID-19? As I've said, the predictions that it will be with us for the next 2 years. And going ahead, even as you open your organizations, we have to look at a way of having in place some of these policies so as to minimize the risk to employees. And why minimize the risk? Now, basically, to minimize the risk in terms of the COVID-19, the reason for this is that under Section 6 of the Occupational Safety and Health Act, it requires that an employer ensure safety, health, and welfare of work of all persons working in his workplace. So it's actually a statutory obligation for employer to ensure that the workplace is in the safety, health, and welfare of their employees in the workplace. And the definition of workplace doesn't just look at the premises that you're operating from. It looks at land, premises, location, vehicle. Those are even the cars that your employees use in terms of their work. Thing, at, in, upon, or near which an employee is or in the course of their employment. So even within that definition, it extends to those within the work from home situation. I know that question has come up quite a bit, is that what is the duty of care of an employer for employees who are working from home? Yes, there is a duty of care for your employees who are working from home. You would need to put in mechanisms to ensure that where they are operating from, at least you know where they're working from, and have they tried to, as much as possible, minimize any hazards or harm to these places or areas. Further, within this duty of care, it is the obligation of employer to be responsible in terms of these risks and minimization of these risks. From the perspective from the work of from home, there are questions of how far or how much should I be providing in terms of support systems and services to my employees who are working from home. Generally, it's supposed to be reasonable support with respect of, let's say, computer systems, access to your online files, virtual meeting software, in order to just facilitate their form of operation from the work from home. Sorry, Art, I'm having a problem in terms of the slide. Okay, thank you. Now, with regards to that same compliance, what happens if you don't comply in terms of the safety, health, and welfare of the employee? Under the Occupational Safety and Health Act, if failure by an employee to comply is an offense and can be conviction, and you might be liable to a fine of up to 500,000 or imprisonment for a term of not exceeding 6 months. Also within the same Occupational Safety and Health Act, an employee can report to the Directorate of Occupational Safety and Health that they feel that their work environment or workplace might be of imminent danger or harm to their health and safety. And it is the obligation of the Directorate to actually follow up on any complaints with regards to the workplace that the employee is engaged in. Now, those are under the Occupational Safety and Health Act. Now, there is also further larger liability under Section 10 of the Work Injury Benefits Act, wherein if an employee contracts a virus or disease arising out of or in the course of employment, they are entitled to compensation under the Act. This is the one that is really the red flag, especially during this period. In essence, meaning that if an employee while at work contracts COVID-19 from a fellow employee while in the course of work, there is the employer is actually open to liability to that extent. And with regards to compensation, well, there hasn't been any live case as it is right now in terms of courts, both locally and in other jurisdictions right now that have gotten to the stage of judgment and ruling. But there are growing cases, especially in jurisdictions such as Europe and in the United States, with regards to exposure of employees. So for the employer's perspective, you have a very high onus in terms of ensuring a safe working environment for your employees, both from a moral and also from a legal perspective in terms of exposure. Now, further to the advisory issued by DOSH on in terms of the policies that employers should come up with regards to their workplace, there was in mid-April a memorandum of understanding that was signed between the Central Organization of Trade Unions, COTU, and the Federation of Kenyan Employers, together with the Ministry of Labor and Social Protection, which was basically coming up with a roadmap in terms of how do we handle employee relations, labor relations during this period of time. The document heavily relied on the element of social dialogue, where in essence, they were encouraging that between employer and employee during this period of the COVID pandemic, which to be honest is very unique to everybody. And we're all facing questions that we've never had to, or situations that we've never had to deal with before. The emphasis was that at least have a discussion with your employee in terms of how are we going to manage working both at home or the workplace. Within the memorandum of understanding, there were elements of in terms of trying to, as much as possible, maintain employees in employment, and then also trying to look at ways of renegotiating or varying contracts of employment through consultation and consent of the respective parties. And then there was also heavy emphasis on the health and safety perspective, where they were looking at least for the employers to provide protective clothing and protective equipment at no cost to the employer. They were looking at employers working in partnership with the Directorate of Occupational Safety and Health to provide adequate information and training on safety and health for the employees. So even as, let's say, your employees are at home right now and eventually they might come back to work, it's really important that you have at least training and information to them with regards to the pandemic and how, as an organization, you're trying to curb it. They were also looking at ways of reporting with regards to anybody who has the virus and reporting directly to official structures created through the Ministry of Health. They were also looking at, aside from just the full disclosure of reporting, looking at ease of movement within the respective areas for employees, and also trying to see how to support employers during this period, considering that a lot of changes might have to be effected in terms of employment and how engagements are done. So this is one of the important documents to consider, even as going ahead in some of the plans that you might have as an organization with regards this how to manage the COVID-19 pandemic. Now, going on in terms of legal compliance, having already discussed what the respective laws, directives, and provisions have said in terms of encouraging employers to come up with guidelines during this period. The first of them in terms of compliance that we advise employers to also really consider is to have clear guidelines and policies with regards to work from home arrangements. As I've already stated, there is the duty of care of employers that extends also to employees from a work from home arrangement. But it is better suited if you have at least a well laid out work from home working policies and guidelines that employees are required to adhere to and prescribe to, that an employee is responsible to ensure that they are not in harm's way or have any physical obstructions or hazards while working from home. So basically explaining to them that within their working environment, they should be able to comfortably operate without minimal distraction, minimal harm to themselves. To a certain extent, for companies or other jurisdictions that have extended this work from home for longer periods, companies have gone as far as even doing home assessments to see whether the home is actually a safe place. Right now, it's not really practical to go into somebody's home to now start doing an assessment, but they've even been having virtual assessments to see if somebody is working within the setup guidelines. But for organizations at this stage, where you are either within work from home, where you'll soon be transitioning back to working from the office, organizations where you're fully at work to home, and you see that this actually work from home might actually extend for a longer period, or it might be the way you'll be operating ahead. It is also very good to have a work from home policy, which is clear to the employee that these are what your expectations and obligations are to the organization during this period of time, to minimize any possible liability in terms of harm or injury to the employee while they're in the work from home arrangement. Also within the work from home arrangement, you need to also consider that there are some who would want to work from home and others who would not want to work from home. For example, in the case of Twitter, where the CEO Jack Dorsey announced that from, I think was it mid last month, that there would be work from home forever for all the employees. But within that announcement, they did put in place a situation where if an employee feels that they're other suited to work from the office, they have the option of working from the office. So a lot of this really requires also a consultation with the employees and also social dialogue into that respect, depending on how long this work from home arrangement will be. Another thing in terms of compliance is ensuring while employees are in the workplace, having the policies in place in terms of social distancing. And this will really require restructuring and redesigning of workspaces to the level required for social distancing. You're looking at probably even considering staggering times when employees come in, one-way walkthroughs where people are not walking through or congregated and crowded at one point. Changing the way you also have meetings, reducing the number of people in meetings from 10 to maybe even 3 or 4, or probably just even having the meetings on different platforms such as Zoom, Skype, Teams that you've already been working from home. And then also setting up seating arrangements in terms of break rooms that make it more easier to comply with social distancing. Another important point to consider in terms of compliance is reinforcement of cleaning within the workspaces. Now more than ever, cleaning has to really be at a higher level. And then we're looking at areas such as door handles, keyboards, printers, and also general areas that employees will be going to. And then also putting in place PPPs, sanitizers, and in certain extent, gloves in certain areas of the workplace that are very common for employees to be touching or have contact with. Now, I know during this period of time, there's been probably a lot of information and probably information overload, but we do encourage that you also stay up to date in terms of knowledge with regards to government directives and any change in legislation with regards to this COVID-19 pandemic. I would say that things have been very fluid and a lot of orders have been coming out. And we see that progressively in June, we'll be going into a stage where government is trying to increase operations and on opening up businesses. And in that process of opening up businesses, they will be creating stringent guidelines in terms of how workplaces should be operating. And you will be required to be up to date because you have a legal obligation, as already stated, both under OSHA and also WIBA with regards to your safety and compliance as an employer during this period of time. At this juncture, I think Emily, you'll come back on to introduce Chacha.
Right. Would you like us to put the second poll at this stage, Regina, or not?
Yes, yeah, we can do the second poll.
Okay. If you can put up the second question. Which of these measures has the organization taken to mitigate the effects of COVID-19 pandemic with regards to employment? Placement of employees on unpaid leave, reduction of working hours and shift adjustments, reduction of salaries, termination of employment, or none. So if we can just quickly see who has implemented what in the various organizations, that would be great. Chacha, you're on mute. So Art, let us know when you have sufficient responses, just to put that up. Just to note for the participants who are joining us, this presentation will be shared. The recording will also, we are recording the session. And I had already made an introduction to the speakers. We have just completed the first session with Georgina, and Mr. Chacha Odera will be taking us the next session. The poll is up. So interesting poll. Reduction of working hours and shift adjustment. I think that's the most popular adjustment being made by various organizations. And let's see what comes up at the end of the session through the Q&A and the chat. So I'd like to hand over to Chacha to take this next.
Thank you, Emily, and thank you, Georgina, for that very informative presentation. Georgina has given us a very clear background of what we are going through. As I said right at the beginning of, at the time I was being introduced, that presently what we are going through is a very, very novel event. History will tell us that the last time we came across something close to what we are going through now is during the Spanish flu. And that was about 1918. I think that's the same year Nelson Mandela was born. And today, it's very unlikely we'll find any person who was around then who is in employment today or who is employing others. So the effect of this has been to literally think through the pandemic and see how best to adjust. To our advantage, the world has also moved. We've got several tools which employers have been able to deploy in order to address the pandemic that they do find themselves. Most important of all is that this is a partnership as between the employer, the employees, and as Georgina put it, the ministry. And that is what in labor terms is referred to as a social partnership. For the first time, I have been able to sit in meetings where the union and employers have sat together and have been able to, at the end of it, shake hands and agree on the way forward. Previously, before this pandemic, the employers and employees representatives have always taken positions of mutual distrust of each other. But for once, this has brought people together. So what are these various measures that employers and employees have deployed in order to coast through this difficult period? First one is sick leave. Sick leave, first and foremost, I must say, is provided for by statute and has always been contemplated in various forms and shapes, but not in the shape and form that we presently see. The regulation of wages, the general order, entitles an employee to a sick leave of 30 paid days and a further sick leave of 15 days on half pay in every given year. An employee who has contracted the virus and is seeking treatment is entitled to apply for sick leave. And in this application and in considering this application, the employer must realize that their duty is not just towards that particular employee, but a duty towards other employees and other people in the workplace. Unlike many other ailments that an employee may suffer, the COVID-19 is spread especially by being contained in a common space. It is a virus which we've had a lot of literature going around. It is spread by droplets. It can be contracted by sharing common surfaces. It is one of those things that cannot just be isolated to that one employee who is seeking time off on account of illness. The other issue is that employees or employers in this particular case, because this is a disease which is not discriminatory, it hits both employers and employees in equal measures. As long as you come across the virus, people have been encouraged that where any such symptoms manifest themselves, the person, whether employer or employee, ought to self-quarantine for 14 days. And initially, you will recall that this COVID-19 was seen as a migratory virus. And the people who were at risk were those people who were traveling beyond our borders. Indeed, I recall when it first started and people were being told, keep away from places where too many people gather. My local church in the village, they said, well, you know, this virus is a virus for you people who travel out of the country. Us in the village, we do not travel anywhere. The farthest we go is the shopping center. So at that particular stage, it was seen to only apply to people who are traveling across borders. But with fullness of time, we now appreciate that we are all equally exposed. It is here with us. And the rule of thumb is really any person who may have come across a person who is considered to be in the vulnerable, either vulnerable person or a person who may have come into contact with other people who would have been in contact with the virus. In the work front, we are being encouraged to self-regulate and to self-quarantine when it becomes necessary. And indeed, this is where, as I previously said, the employer and the employee must work together. It isn't a duty of the employer to be the person walking around the workplace and picking people who should go on self-quarantine. Nor is it for the employer to think that they are immune from it. The moment symptoms manifest themselves or the affected person feels that they need time out, they really need to get out and to self-quarantine as they observe themselves and make the decision of whether or not to return to the workplace. This other option which is being taken both at the workplace by both employers and employees is paid leave. We have recognized that during this time, especially at the time when it started, it took us by surprise, and having not been contemplated, employers and employees have not quite worked out a system whereby the work would be carried out remotely. So most employers, what they did is that anchoring their decisions on the provisions of Section 28 of the Employment Act, which entitles an employee to take 21 working days every 12 consecutive months. This was the time for employers to look into their leave liabilities and to encourage employees who are not needed at that particular moment to take leave. Of course, there was a problem because many times employees would like to take leave at the time when is convenient to them and at the time that they can travel. But in this particular case, we are being told, take time out, but the government of Kenya is telling you, as you take your time out, you cannot travel, and there's curfew and there are all these things that go with measures which the government had taken. If you look at most employment contracts, they talk about taking leave at the convenience of the employer. And the Employment Act doesn't help much because all it does is to prescribe the number of days an employee ought to take leave. So dealing with that was not very difficult. It was a question of putting people together, telling them that this is the most convenient time for the employer to release you to proceed on leave. The other issue which came up as we went deeper into the crisis was unpaid leave. If you look at the statute books, which are the contracts of employment entered into between employers and employees, there's no provision for unpaid leave. But this was something which employers were required to engage with employees to be able to agree for employees to take time out and go on leave without pay. It wasn't the first option, but it became an option as we went deeper into the crisis. Business was no longer raking in revenue, and the only way to save the employer from going into insolvency was to explain to the employees that we need to preserve this business so that when we are through with this crisis, we'll still have a place to go to. And properly communicated, employees in many instances have been very cooperative. They have looked at it as part of the effort to save this business so that with the optimism that we all have that we will ride through this storm, we will have somewhere to go to. So in sending an employee to unpaid leave, it can never be a unilateral decision of an employer. It is something which the employer and an employee have to sit and sign off. So my advice has always been to employees, be reasonable about it. To employers, also you be reasonable about it. The fourth option that other employers and employees have explored is reduction in working hours and shift adjustments. This serves two purposes. Firstly, in reducing the working hours, it enables employees and also the employer be able to comply with the government requirement that people must be indoors by 7. As Georgina had earlier on said, by 5 o'clock, if you're to release people at 5, by the time they get transport, which probably the last public transport will leave the bus stage or the pickup point at 6, it will be very difficult for employees to make it home in time to be to comply with the curfew requirements. So employers have been forced, or not, I wouldn't say forced, but in acting reasonably, they've appreciated the need to reduce those working hours. And most employers are reducing employees by 3:30, by 4, employees are out. The other thing that the employer has done is this shift adjustment. And that is really to ensure that this social distancing requirement to contain the spread of the virus is contained. What do I mean by shift adjustments? We have an office, for argument's sake, of about 70 members of staff. One can work it in a way that 35 work from the office and 35 work away from the office. It requires thought. It requires people being able to equip those working away from home to be tooled enough to be able to carry out their obligations under the employment contracts. Of course, this becomes a problem if you're a manufacturer or if, let's say, you're a bank employee. Earlier on, I had seen something on the social media where when an employee was found with a sack of money walking out of the bank, the man was a bank teller. His defense was that he was going to work from home, and any customer who wanted money can come to his house. Of course, that was said with a light touch. What that joke told us is that not all work can be done away from the workplace. And again, this is something which the employer and the employee must sit together and work out a way how best can we utilize each other in order to carry out our various responsibilities within the workplace. And again, as I earlier on said, best done in consultation. And you'll be very surprised that the more people talk with each other, the more people consult, the more people understand that this is a crisis that affects all of us, the more there is the possibility of getting into an agreement. The other measure which employers have done is reduction of salaries. I'll tell you that I was admitted to the bar 32 years ago, and I've worked for 32 years. And never in my life had I ever thought that the issue of reduction of salaries would ever arise. We always, as lawyers, said it's contractual. We've agreed on how much you'll pay me, what you'll give me, and that's what you must pay and that's what you must give me at the month's end. But in all this, we never ever thought that circumstances can arise where we need to rethink of what we had agreed upon. And one of those circumstances is this circumstance that we find ourselves in. Good example is restaurants. You were told before the issue of 2 beers and 1 sausage came about, restaurants were closed. You're a waiter. You can see very well that there's no traffic coming into the restaurant because the whole question of social distancing wouldn't permit patrons to visit restaurants. And also just the fear that you're not too sure about the way the place has been sanitized. So people are not going to restaurants. How then does an employee insist that in spite of revenue is not coming in, I must get my full pound of flesh? This is where a proper conversation between an employer and an employee, properly conducted as with respect, you'd find was now leading to reductions in salaries. There have been some cases where people have filed suits in court. But as Georgina will tell you, all those cases, when you go back to them, you will find that those decisions to reduce salaries were made unilaterally. And many a times the employees merely found a communication on in their inbox. And the tone of the communication was either you take this or you leave it. So I have shared 2 particular cases that are pending in court, and I don't propose to discuss those because they are in court. But those are really the measures that have been areas where employers and employees have explored in order to work together through this crisis. Thank you very much. Sorry, there's the other one, redundancies. Redundancy, the problem with it is that it's expensive. Redundancy, it's not just a question of jobs falling off. It is a question of it goes with a cost implication. And at this particular time, when there are no revenues coming in, it is not an easy, option to take. Yes, so I hand over to the next panelist to discuss the future of work. Thank you very much.
Georgina, are you there to take it on?
Yes, before that, we are going to have a poll. Emily, you run with that next poll just before I take on the future of work.
Yeah, so the next poll is, do you have a continuity plan for your organization? Do you have a continuity plan for your organization? So very insights coming up there as the poll is going on. I just want to say thank you for the comments on the chat box. The participants are really appreciating the insights that are being shared, and quite a number of questions as well coming up. Hopefully we'll be able to answer some, if not most of them, before the end of the session. So Earth, let us know the right time to broadcast the results so that Regina can take it on in the interest of time.
Okay. So from the poll, we can say the question was, do you have a continuity plan for your organization? So 71% said yes, and 29% said no. And the reason I asked this question is that now that we have established that COVID-19 is with us for a longer period of time than expected, and that within the next month or two, we'll be looking at upscaling in terms of operations and businesses within the country. We're looking at a situation where we need to now come up with a plan on how we'll be operating as an organization. I had already discussed at length the work from home arrangements and plans. And from our perspective, we're looking at a situation where all organizations are, at least, if you're going to take the option of working from home, going ahead. And I really do see a shift in organizations, at least wholly the organization will be working from home, or having large sectors or segments of the organization having the work from home arrangement. If that option is one of the things that are in consideration in your continuity plan, you really need to look at the policy and guidelines from this work from home. We've already seen numerous cases coming up within other jurisdictions with regards to liabilities of employers for any injuries or harm caused during the work from home. There has been quite extensive litigation in the United States because they had, for the past, probably the past decade, have been moving towards a work from home arrangement. So there have been cases coming up from that end. From a local perspective, this is really quite new territory for a majority of the organizations. But then after this COVID situation, we will see the increase in terms of work from home arrangements. So these policies and guidelines really will help in terms of reducing your liabilities with regards to the harm caused at home. And as recent as yesterday, I did see a case from Switzerland whereby the courts had ordered that in a work from home arrangement for an employee, that the employer pay a portion of the person's rent. So these are some of the new things and that we need to look out for and consider in terms of our work from home arrangement, and might be creeping in also within our jurisdiction to that respect. The next thing in terms of future of working from home is flexible working hours. Basically, the flexible working hours breaks the traditional norm of the rigid 9 to 5, 5-day week structure. As in its core, as an arrangement, individuals have greater freedom over where, when, and how they work and fulfill their particular roles. And this has been seen during this period of COVID-19, where you're not physically seeing your employees, but you have deliverables and also action points that each person has to deliver within a period of time. And this has shifted the way probably organizations are looking at performance and operations within themselves. So basically also within your respective HR policies and contracts, we always have that one clause that says that you're supposed to report to the office at 8 and you leave at 5 p.m. This will be really seeing a shift on, but we also say that even as you have your flexible working hours, also make it also be cognizant of the fact that really having emails at 1 a.m., 2 a.m., 3 a.m. to an employee and expecting deliverables during that period of time might not really be practical. And there have been cases in countries such as Denmark and France about employees working beyond certain, I think, reasonable working hours, like receiving calls at 10, 11 p.m. And that has also created liability. So these are some of the things that really going ahead you must look at in your policies. We also see a real reorganization and restructuring from both a financial and operational perspective for organizations to ensure efficiency. Then comes in the element of probably reducing the amount of manpower, or in terms of redundancies, and probably shifting people into different departments. We also predict that there will be renegotiation of contracts of employment. such as casual employment, term contracts, and permanent engagements. In the past, I would say past decade, we've really seen a reduction in terms of permanent engagements. It's very rare in this day and age to have open-ended contracts. Most of them usually are based on a term period, and this also reduces in terms of your review of a person over a period of time. And then once a project is concluded, then now you could really consider whether you're going to renew the contract or not. Going ahead, as I already mentioned, we are seeing that in the next 1 to 2 months, there will be upscaling of businesses. And we've looked at a perspective of both South Africa and the United Kingdom with regards to this upscaling. The first is in terms of South Africa. They experienced a complete, total social and economic lockdown on the 26th of March, 2020, which in some newspapers and articles that I read have been described as the most harshest lockdown seen globally. They have recently come out of it with a lot of cheer, but in the process of coming out of the lockdown, the government has had to put in place still restrictive measures in terms of upscaling of operations, specifically in workplaces. We noted that when we're looking at some of the upscaling plans under the directives given by the Minister of Employment and Labor in South Africa, we noted that there was quite a bit of similarity with some of the provisions we already have given to us by DOSH in terms of giving a direction to the directorate on how you as an organization will be now upscaling and allowing employees back onto the workplace, and then also putting in place health measures during this period of time, and also in terms of minimization of numbers of workers in the workplace by adopting a shift system and also achieving social distancing. They also, through their plans, have been looking at risk assessment, where you as an employer have an obligation to assess from your perspective some of the risks that are to your employees if specifically they move back to the workplace. And this is some of the reports that have to be given to the Ministry of Health or DOSH. For now, we still don't have those directives, but we do see that this is one of the things that would be coming up soon. Another country that is now upscaling in terms of operation and in the workplace is the United Kingdom. They also had a lockdown from the 23rd of March 2020 up to the 10th of May. And when Prime Minister Boris Johnson set up the roadmap for easing lockdown, his plan was to try and bring the country back to normalcy. To be honest, I don't know about normalcy going ahead, but I think what they were trying to aim for is that try to bring back work, businesses, operations, but work within strict guidelines in terms of managing COVID-19. So they still have encouragement in terms of work from home. They've also set up work for a COVID-19 risk assessment with consultation with workers and trade unions before workers return back to work. Very strict social distancing measures of 2 meters apart. So in essence, basically, most of the organizations really need to now start redesigning their workspaces and also reinforcing the cleaning processes. So in conclusion, and just to bring everything around in terms of your continuity plan, these are some of the things that really you need to sit down, consider, and come up in terms of when you do upscale your respective businesses, or if you're already in the process of upscaling or have upscaled, do you have the requisite guidelines, policies, especially during this COVID-19 period and going ahead for at least the next 2 years? To that end, I'll hand over back to Emily. Maybe we can look at some of the Q&A questions.
Great, thank you so much for the elaborate presentation from you, Georgina and Chacha. And for those of you that are coming in, we started by looking at some of the statutory obligations for employers from health and safety and occupational perspective. We had 2% of you saying that you have already have a policy in place that looks at OSHA. And then we went ahead to look at what are some of the adjustments that employers are having to make, including sending their employees on unpaid leave. Others are having to, reduce salaries. adjust the working hours and all kinds of changes going on. And we also had quite some interesting insights up there. 51% have actually done a reduction in shift and change in working hours. Some have also had some level of reduction in salaries, and we will be sharing some of these statistics. And again, just to appreciate that it is actually coming from the population that's attending this forum, but I do think it's been quite insightful, and also to the future of work, saying what does this mean for us and employers in general, in terms of the policies that we had that now need to change, and really shifting our thinking in how the workplace will look like in the future, including having in place contingency plans. At this point, I would like to maybe look at some of the questions. We have 23 of them, and don't worry if we don't cover all of them in this session. We will be sending the written responses later at the end of the session. But for now, I'd probably pose the first one to Georgina, which is, as we are all working from home now, does OSHA come into play? And also, are employees covered under WIBA while working from home?
Yes, as I said in my the initial conversation on working from home arrangement, yes, both OSHA and WIBA do come into play, in sense that when looking at the workplace is defined as anywhere that the employees undertaking their work, and that extends to also working from home. And with regards to liabilities for any harm or harm in terms of injury or contracting any diseases at home, yes, there is also liability to the employer with regards from work from home. So yes, they do apply. And there is a duty of care by the employer during the work from home arrangement.
Okay, and I think maybe this one I'll pose to you, Chacha. I've had a lot of questions coming about the issue of changing the terms of contract or reducing salaries. And I see a lot of emphasis on consultation. What happens if the employee doesn't agree?
Okay. Thank you, Emily. But just permit me to just first add to what Georgina said. In strict sense, yes, an employer would be liable, but there's an interplay of privacy. If an employee tells me I can't come to their house, I can't go to their bedroom from where they work, and at the same time it's them who are in control of their premises, I think each case really will have to be looked at, because as we said earlier, all of these pieces of legislation were drafted in the old normal. Now we have a new normal, and we will have to address that. Georgina is right in assessment of this, but I can see litigation coming out of it in terms of where does the employer's duty end and where does the employee's duty begin. So on what you've asked me, changing terms of contracts, as you do appreciate that employment by its very nature is a contractual relationship, and once we've both appended our signatures, we are bound by the terms. Where we are now unable to carry out our respective obligations, then we must start looking at a way out of it. For a long time, there's been argument as to whether the doctrine or the principle of frustration would apply. And now more and more, and I think Georgina did share with me some decisions, the courts are now appreciating that a time comes when a contract can be frustrated on the basis, not merely that it is onerous to perform, because that's not a basis for declaring a frustration, but has become impossible to perform. If I don't have income streams, I can't pay your salary. The choice is either I can declare that the contract is frustrated, or worse still, I can go onto an insolvency and say I'm unable to pay my debts, which means I'm going for winding up of the business. And if we are to wind up the business, all other creditors then are invited to also participate in that winding up. And the employee may come out with very little. There's only so much that the act guarantees their payment. So when it comes to negotiation, it's only in very extreme circumstances that you will find people may reject, renegotiate a contract with a view of reducing their emoluments.
Right. Kindly explain the scope of employer's duty of care to the employee working from home?
Since I raised that issue, let me try and jump onto it. I think Georgina had touched it briefly as extending to providing the necessary tools for the employee to deploy in order to carry out their work. So, and again, it will depend on the nature of work. Let me now talk as a lawyer. I have a good amount of our colleagues working from home. And what have we done in that respect? We have supplied them with their devices. They do have internet access, and we do have a document management system which enables them to be able to work, to access the documents from the office, their files and all. I am not sure whether that duty would extend to ensuring that there's no leak of their gas in the kitchen or in other respects. I think, as I said, that duty has to be looked at from on a case-by-case basis. I would not, I mean, it's too wide a question. I think as and when you have a problem, you can consult Georgina and give them the specific circumstance you find yourself, and Georgina will be able to advise you as an employer what would be expected of you.
Right.
That's correct, Chacha. Yeah. And just to add on, actually, while I was actually doing research for this, there isn't any legislative indication for work for home for most of the jurisdictions we looked at. And we looked at both countries in Europe, Australia, and America in terms of what exactly am I supposed to provide somebody from work from home arrangement. But the closest we could find is that, as Chacha has said, and also I indicated in the discussion, is that at least give them the computer systems access, and then also like right now we have access in terms of virtual systems, Zoom, Skype, to be able to do their work, anything that requires them to be able to do their work. And in terms of litigation on the matter, just having that, if you're having a work from home arrangement, just also make an inquiry in terms of where the person is working from home. An employee can even come and tell you that basically where I'm working from home is really not safe for me to be carrying my equipment back and forth. And we've had situations where employers have rather had those people who feel they can't work from home, either work from the whole office or from another designated point that is more safe. So it's really from a case-by-case situation.
Okay. We have an interesting one here. Some employers have terminated their employees, citing frustration. Is that an option available to employers to terminate on grounds of frustration? If not, what sort of liability is the employer exposed to if they have already proceeded to do so?
My advice has always been that frustration should really be at the tail end. It cannot be the first option. And in citing frustration, it's not just a question that it has become onerous to carry out your obligation under the contract. You must show it has become impossible to carry them out. So the various case laws have set out the conditions precedent which one must meet before you cite frustration. It's an easy option out, but I can assure most employers that are using it as your first line of action may present you with a possible suit for unfair termination.
Mm-hmm. Thank you, Chacha. If an employee tests positive for COVID-19, should the employer let other employees know?
In terms of this situation, their first obligation in terms of disclosure is actually to the Ministry of Health, and that can be done to the Directorate. But in terms of disclosure to other employees, no, you'd be infringing in terms of the privacy of the employee. But keeping in mind that the exposure level to your employees, you need to put in terms of mechanisms where you have to, once it's confirmed the person has it, that and the other employees are possibly exposed to it, probably give information in terms of that contact. I know there is a case, as I was watching the news yesterday, there was a case where one of the banks had it was a teller got COVID-19 from one of their clients, and they've now had to shut down the bank in terms of the security guide, the safety guidelines. So your first point of disclosure is with the respective government authorities, but in terms of identifying the employee and disclosing that to other employees, no, as an employer, you have to, you would be infringing on the privacy of the other employee.
Mm-hmm. So I'm just checking for time. Sandeep, how much more time do we have?
I think, Emily, we possibly do another 10 minutes. I think there's still many unanswered questions, although, as you said, we will share them with everybody. So maybe, should we do another 10 minutes?
Sure, makes sense. Yeah, I think very good question, great questions actually, and I think quite pertinent. So this one says, do you foresee a situation where employers will be sued by employees alleging wrongful termination, considering employers are downsizing due to COVID-19?
Yes, I think there will be many cases. And as I said earlier, each case will be determined on its own merits. And it also depends on how the employer did it. And that's why many a times our advice to employers is, let's talk and let's consult. Let us, where it is possible to get some working agreement, it's better you take that rather than use your elevated position to get rid of people. Suits will be there. In fact, Georgina is already researching on many of these things. That's why all these things are on her fingertips.
Okay, thank you. So, and what happens when an employee has exhausted sick leave? I don't know whether we answered this already, and maybe they have contracted the disease. What happens, Georgina?
Well, generally, even before the COVID-19, when it comes to matters in terms of sick leave, we always advise this is something that really should be consultation between the employer and employee. As indicated under the regulations of wages general order, you have at least a maximum of 30 paid days and then 15 days thereafter on half pay. So that is already a total of 45 days in terms of sick leave. Any other extension beyond then would basically be a discussion between the employer and employee, also assessing what the employee is going through, because sickness can come to anybody, and in some situations it can be really extended over a period of time. However, if a position reaches where really the employee cannot operate and it has, you've already extended your benevolence to a longer period of time, because it really is a discussion that has to be done from a very light, sensitive note. You are required, even before terminating the employee on the basis of health, you have to have at least an assessment done by the directorate. This comes out of decisions from the Employment and Labor Relations Court, saying that it is not enough for an employer to say that the person is sick, we terminated them. There has to be a report done by the directorate of health and safety, indicating that the employee can no longer undertake their functions, and then have a sit-down discussion, not a disciplinary hearing, but more like a meeting with the employee to explain the extent of this and that their termination is on the basis of health reasons. But we always say again, please continue on with the social dialogue and consultation before you go into any positions of termination.
Right. Right, and just from a very practical angle, Georgina, can you then take the annual leave if you exhaust your sick leave?
Yes, and that is also another consideration, because if you explain to the employee that you've exhausted your sick leave, we're now in the situation of taking annual leave, and they agree to that, then going forward, that can be another option. Some go to the extent of even being on unpaid leave, and then once they are back on their feet, they come back. Because for a lot of organizations, you see, even that sickness of the employee is linked to probably medical benefits that you're already giving the employee. So you'd also be looking at it from the perspective that you're not ready to probably terminate this arrangement, but you still want to keep them on, and when they're ready, they can come back. So those are avenues that can also be explored.
Okay. Maybe two other questions and then we can wrap up. What is the limit, reasonable limit on unpaid leave in this day of COVID?
That's a difficult one because it all depends on the circumstance of each company and how, because at one particular point, a decision will have to be made as to whether they want to shut down. We've been having a discussion on a separate issue where our client would rather go for a redundancy with an option to re-employ whoever is declared redundant when things pick up. And the other side are insisting that they want unpaid leave. The difficulty of an unpaid leave being open, not having a sunset date, is that employees go away without any money in their pocket. And the employer, as we've recognized, can say this crisis, there will be the crisis period and the recovery period, which may go as long as 2 years. So if the agreement is that we are going to go to unpaid leave for as long as this crisis persists, then I guess it will just have to be that. Many times people would rather have a discussion that let's first start with so many months and then we review from there and we agree which way forward. So each company really would have to look at their respective circumstance to make those decisions.
Right. And what happens to employees who are not open to salary deduction? They refuse consent, and they can the employer terminate the contract legally?
Yeah, this is a very popular question. Well, the position that we have been advising and taking is that if for them to take a salary reduction or any change in variation in their contract of employment, it requires consent of the parties. If they refuse to do so, then you're carrying on with the contract of employment as you had already engaged initially. A lot of employers would say sometimes this might not be sustainable and we would have to probably let go of that position. In terms of sustainability, even from a financial perspective, you'd be looking at if that position is not sustainable and you can probably restructure and rework your organization to fewer numbers, minus that position, you're looking at a redundancy situation. In terms of termination, because the person refused to take a salary reduction, that is not a fair and valid reason for the termination. So you're looking at the first option is further social dialogue to explain to the employee, this is where we are as an organization in terms of what we're doing right now is to keep the company afloat for everybody. And then if that social dialogue really cannot come up with anything viable, the next step you're looking at possibly maybe a mutual separation. And to the extent that now that position can no longer be maintained both from an efficiency and financial perspective, possible redundancy process, which also has a financial element to it. So you're looking at carefully addressing the matter on the action of social dialogue.
Right, so there's really a number of other questions, and I just want to assure the participants, all the attendees today, that we will look into all of them and provide written responses that will be shared with you later on. At this point, I'd like to really thank the panelists. Thank you so much for your rich knowledge and information sharing with us today. I think these are really pertinent issues, challenges we are faced with as employers every day. And that's why I think it's important that we take time to address each and every one of those questions today. Thank you, Zamara, for hosting this webinar, for hosting us. I hand over back to you, Sandeep, to close the session.
Thank you very much, Emily. I think you've said it all. This has been a very engaging discussion. The two panelists have really done justice to this topic. Thank you both, Chacha and Georgina. This was wonderful. I really wish we had a little bit more time, but I'm sure we can organize another session. And thank you to everybody for their participation. So thanks again, everybody. And thank you, Emily, for being such a great moderator. So goodbye. Have a great day and week, everybody. And look forward to another session with everybody soon. Thank you. Bye-bye.
Thank you. Thank you. Bye. Right.